morning, everyone. It's March 24th, 2025. It's 10 o'clock a.m. We're here for the regular meeting of the State Ethics Commission. We're called meeting to order. It looks like we've got an agenda. It's in 9 parts. Has everyone had an opportunity to review the agenda? Do we have any changes as the agenda is presented, Mr. Amadi?
We do, Mr. Chairman. Situate this a little differently. In Part 3, preliminary hearings, Position A, 24-0083C, in the matter of Atlanta DSA, that is being removed and continued to the June meeting.
So it's not being removed necessarily from the preliminary hearing as a preliminary hearing matter.
It's just being continued. Correct. That's correct.
Are there any other changes to the proposed agenda?
No, sir.
Yes, sir. There's one under Category 4, consent orders, D, case number 24-0086 in the matter of Joseph Mark. We're going to move that to June. We haven't gotten an executed consent agreement on that case.
Okay. If you don't have an executed consent agreement for that case by the June calendar, then it's going to be set for preliminary hearing in June, okay?
Yes, sir.
All right. Do we have any other changes from the staff with regard to the agenda? All right, hearing none, subject to the amendments, I'll make a motion that we approve the agenda as presented. Do I have a second?
Second.
We got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, so we'll move on with the agenda as amended. We've now got item 2 on the agenda is the review and approval of the meeting minutes from our last meeting on January 15th of 2025. Has everyone here, all the commissioners, had an opportunity to review those minutes? Any questions to pose to commission staff with regard to the minutes? All right, hearing none, I'll go ahead and make a motion to approve the meeting minutes from the January 15, 2025 meeting as presented. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right, those meeting minutes will stand approved. It looks like for item number 3 on the agenda, these are the preliminary hearings. Given that the first case has been continued, we'll move on to the second case. We'll call that case as case number 24-0108C in the matter of Anna McCoy. Mr. Baywall, looks like that's your case?
Yes, sir.
Has there been any communication at all with Ms. McCoy?
There was communication back in October when the complaint originated. We also talked in early January. This was a matter that we had resolved verbally over the phone. And I told Ms. McCoy that I would send the written consent agreement, the draft, to her for review and signature. And once that occurred, I had not heard from her since.
Okay.
And I
You got
did
good service on today's, the notice for today's hearing?
Yes, sir. That notice went to the address that she used to register with the commission. Her last filing also occurred in December of 2024, and that was the same address that she used for that filing as well.
Okay. You can go ahead.
All right, and this is in the matter of Anna McCoy, case number 24-0108C. The violations I'll be presenting to the board today. There's one violation of OCGA 21-5-34C2A. Ms. McCoy failed to file her December 31st, 2021 election year CCDR. Violations 2 through 6 are all violations of OCGA 21-5-34C1B. Those are violations for failing to file non-election year CCDRs. Violation 2 is the June 30th, 2022 CCDR. Violation 3, the December 31st, 2022 CCDR. Violation 4, the June 30th, 2023 CCDR. Violation on August 18th, 2021. This complaint originated after an internal audit in Villa Rica. We filed the complaint on October 28th, 2024. Procedurally, there was an error that I made on the October 28th, 2024 complaint, and that was just with, when I listed the statutory sections for all the non-election year CCDRs, I got my Cs, 1s, 2s mixed up, but that was the purpose of the addendum and amendment that was filed on February 20th, 2025, just to inform that when I alleged the non-election year CCDR violations, I just mistakenly put the wrong statutory site. So that was the purpose of the addendum and amendment to the original complaint, and that was just to notify Ms. McCoy of the error of the statutory site. As I indicated earlier, I did talk with Ms. McCoy in October 2024, right after the complaint went out. I talked to her over the phone, explained how she could become compliant with the law. I also gave an overview of the complaint process. Again, this is something that we verbally had pegged as a consent agreement, and this is something that we were trying to get on the December board meeting, and our numbers were a little bit high, and we kind of backed off the week before. We stopped scrambling to try and put things on that calendar. Then when we came back in January of 2025, I was asked to add as many consent agreements to that calendar as we could. I talked with Ms. McCoy on the phone. We worked out an agreement on this case. I told her I would send her a consent agreement after the phone call, and that was sent within the hour. Never heard back on the consent agreement. Went up into the January 2025 board meeting, still had not heard back from her. I have emailed her multiple times. Each 3 successive weeks after that January board meeting, I placed calls to her, and the last I heard from her was early January. So I thought we had a resolution in place. It wasn't an egregious amount that we were seeking, but it was just something that she never executed the document, and she's since lost contact with our office. The notice of preliminary hearing was delivered to 5014 Cambridge Lane in Villa Rica, Georgia. That's where the complaint went. That's, again, the address that she used on her DUI, and she did make a filing in December of 2024 with that same address.
Commissioner Thompson?
Okay, so if I'm reading the analysis right, you're saying that she did file a $2,500 affidavit?
She originally filed the $2,500 affidavit in 2021.
Okay. And this is just speaking to the campaign finance part. I understand the violation of the PFDS because there's no affidavit for that. Do you know if she has accepted any money or spent any money after the December 31st?
She is not.
She hasn't accepted anything or spent anything?
Correct.
Okay. So,
That's according to her filings.
or according to her bank statements?
That's according to what she told me.
Oh, okay. But you don't have her bank statements?
No.
Have you guys stopped being subpoena happy? Because you
Well-
used to subpoena everybody.
In this case, when I talked to her originally, she told me that her campaign was self-funded. She didn't raise the $2,500. She had an active bank account with $50 of her money in it that she was keeping open, not knowing whether she'd run again in 2025 or not. That was also consistent with when we take a complaint, I'll look online to see what type of activity I see. You can kind of get a sense for whether somebody has a big campaign with Google, Facebook. You can see if they're doing T-shirts, signs, things like that.
So my question is this. Is it not true, and maybe you haven't been here long enough, that there has been a lot of confusion on when the next $2,500 affidavit or $5,000 affidavit has to be submitted for each election year?
I don't think there's confusion on that.
But you don't think there's confusion because you're an attorney. But has there not been confusion with the city clerks in the counties and stuff like this? My point is this. My point is that it appears that she tried to do the right thing here. by filing an affidavit, okay?
Correct.
I've had city clerks call me and ask me when the next one is. And I've had conversation with ethics staff or staff attorneys and the executive secretary as well. And we've had conversations because it has been somewhat unclear in the past. We're going back to 2021, okay?
Yes,
So I'm
sir.
not saying currently it is. I like being egregious, don't get me wrong, okay? But I think, and I don't even know what we were proposing for this, I understand technically there's a violation here because she didn't file the affidavit, but, I mean, as far as it goes, we don't know if she spent any money, we don't believe she did. I know it's just a preliminary hearing. I mean, if this is the posture we want to start taking, then I'll be fine with it, I'm only one vote, but I just wanted to see if we even knew whether or not she spent any money, and could this just been a mistake as far as the campaign, not the personal financial stuff. And I don't appreciate her not coming in, I'll say that too, or finishing up your negotiations.
Well, I mean, I think that's the point. The point here is not necessarily what happened with respect to any negotiations that may have occurred between Mr. Baywall and Ms. McCoy. The point here is that what we know is that 1 through 7, those violations occurred. Now, again, we're not saying that if we don't find out later that, other violation, that, she may have committed other violations. And you and I have actually had this discussion before during commission meetings about whether you have to charge her with every violation right now, or is it with the violations that we find out about that we have supported evidence for, down the road, as long as there isn't a statute of limitation problem, right?
Yes, sir. And I'd like to discuss the $2,500 affidavit issue that you raised, because number one, the statute says that the affidavit applies for the election cycle when it's filed. And
You bring me 50 people in here, and only one person is gonna know what an election cycle is,
I understand that.
and that person will be you.
I understand that, and that is in the law. Also, the actual affidavit that they file, it does say that it's good for that election cycle. But you are correct, but
Wait, what do you think? Is that the same thing as being right?
you sound like my wife right now. So essentially what happens is, this is what happens. When somebody files the $2,500 affidavit, that runs through the election. When the election is over, they have 3 options. Number one is they can keep their campaign account active, and now they're under the default schedule that's listed in 21-534, which is file the 2 non-election year CCDRs, and then when the election year comes around again in 4 years, then you're on the 6 reporting period schedule. That's option 1. Option 2 after the election is keep your campaign account active, file the $2,500 affidavit. Option 3 is terminate your campaign account. It is a common fact pattern that we get, that local candidates, they get to the election, they file the $2,500 affidavit for that election cycle, and they think they're all done. That is a mistake. In this case, we ran the audit 3 years after she ran for office, so she picked up all those non-election year CCDR violations. I will say though, knowing that, yes, she just missed one filing, it was a misunderstanding of the $2,500 affidavit rule. When I tried to resolve this case with her, I didn't stick her with 6 late fees and 6 civil penalties. I said what we're going to do is since you had $50 in your campaign account, since it was your money, the violation is you forgot to terminate your campaign account.
This is not why we're here today.
I understand that.
But I really don't want to hear anything more about the negotiations that took place with Ms. McCoy on the road to some consent order. The only place we are today is are there reasonable grounds to find that Ms. McCoy violated the Campaign Finance Act in seven different respects. Now, a minute ago, you just said, I agree to something that Commissioner Thompson said. I'm really curious to know what it is that you agree with, because if you're agreeing that there's some problem with the applications of these code sections to what she did, then I'm not sure that we can find reasonable cause. So what exactly was it that you just agreed with him about?
My agreement is there's misunderstanding sometimes with candidates as to what the law is. My agreement was just simply that you do see this violation from time to time. This isn't a one-off thing.
Mr. Armani?
I think, and the vice chairman can correct me, but I think his issue is with the affidavit existing in general. Is that fair?
Let me see.
But because your concern is people file the affidavit, they think it just carries them through. They don't understand that it expires and they have to refile it, right?
That's true, but I'm gonna take a step back to something the chairman said. This isn't why we're here today, right? Just because there's misunderstandings, that's a conversation, I guess, for the commission to talk to you about getting the understanding out there properly, because, you know, it's not. To the chairman's point, we're not here for that. You guys brought it in front of us. We have to determine whether or not there's reasonable grounds to believe it's violated. And from the facts, even though I disagree that we should move forward, that's our job for today.
I'll just point out that a misunderstanding as to the affidavit is something that maybe the board should consider for mitigation of a penalty, but it doesn't excuse a violation of the law. Which is, to the chairman's point, what we're here today, and I'm gonna try and bring this back to why we're here today. Whether there's confusion with locals on the affidavit or not, ultimately she didn't file the report she's required to file, correct, Mr. Maywall?
Yes, sir.
And that's what I think we need to focus on is, she didn't file the reports that need to be filed. I'm gonna let you continue your presentation in a minute, but that's what this board is considering at this posture.
Mr. Maywell?
Yes, sir. The applicable law violations 1 through 6, the law is contained in OCGA 21-5-34 C1B through 2A, and this again is the non-election filing schedule. It's June 30th and December 31st of each non-election year, and the election year schedule, January 31st, April 30th, June 30th, September 30th, October 25th, and December 31st. That's the applicable law for violations 1 through 6. Violation 7, OCGA 21-5-50A. This is the law that governs when candidates must file the personal financial disclosure statement, or the PFDS. Has to be filed within 15 days of qualifying, and then every public official, when they take office, they have to file this document before July 1st of each year that they're in office. The evidence in this case, this is Ms. McCoy's filing history. You can see on August 18th, 2021, she filed her DOI. On August 18th of 2021, she filed the $2,500 affidavit. That covers her through the 2021 general election. The next filing that she made, and this was after the complaint, this was after I talked to her about compliance, after I explained to her the 3 options candidates have who file the $2,500 affidavit and then go to the election, I explained that to her. The next 2 filings she made, she filed another $2,500 affidavit December 30th, 2024, and then she also filed a termination statement December 30th, 2024. That's for her campaign finances. Those are the loan reports that she filed. For the PFDS filing, I just highlighted the one deficient filing that she had. Her calendar year 2021 PFDS, it was filed 21 days late. It was filed on July 22nd, 2022.
So my question is for the attorneys, is you can't backdate an affidavit.
Correct.
So that means she wouldn't be able to rectify this problem anyway. I'm asking from a legal standpoint, not any other thing. I mean, the law does not, so there is no solution besides her terminating or doing exactly what she did, okay? So there's nothing more she should have done. I mean, there's nothing more she can have done.
Once the violations of the law had occurred, yeah, there's nothing she can go back to.
I just want to make sure.
Yeah.
Mr. Chairman, at the right time, I'll make a motion.
And again, the analysis on this, violations 1 through 6, she filed the $2,500 affidavit. It went through the November 2021 general election. She had no other filings regarding her campaign finances until December 30th of 2024. So essentially, she missed that December 31st, 2021 election year filing, And then for 2022 and 2023, she missed the June 30th and December 31st filings. Going into 2024, she missed the June 30th, 2024 non-election year filing, and then in October of 2024 is when we brought the complaint. So that's the analysis on violations 1 through 6. Violation 7, you saw that the filing was 21 days target. And the reasonable grounds findings that I'm presenting to the board are listed here, violations 1 through 7.
Commissioner Thompson?
I'm gonna make 7 separate motions. The first motion is to find reasonable grounds that the respondent failed to file her December 31st, 2021 election year CCDR in violation of OCGA 21-534C2A. Do you want me to make all 7 at once? Or?
No.
Okay, one.
Do we have a second? I'll second it. Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye.
Aye.
Any opposed? Carries.
The second motion would be that the respondent violated, there's reasonable grounds to believe the respondent violated the Ethics of Government Act by failing to file her June 30th, 2022 non-election year CCDR in violation of OCGA 2153C1B.
Got a motion, is there a second? I'll second. Got a motion and a second, any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Third motion is that there's reasonable grounds to believe the respondent failed to, the respondent has violated the Ethics of Government Act by failing to file her December 31st, 2022 non-election year CCDR in violation of OCGA 21-534C1B.
Got a motion, is there a second? I'll second it. Got a motion and a second, any discussion? All in favor say aye. Any opposed? Motion carries.
My fourth motion is the respondent, there's reasonable grounds to believe the respondent violated the Ethics in Government Act by failing to file her June 30th, 2023 non-election year CCDR in violation of OCGA 21-534C1B.
Mr. Baywell,
Yes, sir.
is the original complaint the one from October 28th of 2024?
Yes, sir.
I got you. Okay, got a motion, is there a second? I'll second it. Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye.
Aye.
Any opposed? Motion carries.
Fifth motion is that there's reasonable grounds to believe that the respondent violated the Ethics in Government Act by failing to file her December 31st, 2023 non-election year CCDR in violation of OCGA 21-534C1B.
Got a motion, do I have a second? I'll second it. Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye.
Aye.
Any opposed? Motion carries. Next.
The sixth motion is that there's reasonable grounds to believe the respondent violated the Ethics in Government Act by failing to file her June 30th, 2024 non-election year CCDR in violation of OCGA 21-534C1B.
Got a motion, is there a second? I'll second it. Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye. Any opposed? Motion carries.
The last one, number 7, is that there's reasonable grounds to believe that the respondent violated the Ethics of Government Act by failing to timely file her calendar year 2021 PFDS in violation of OCGA 21-5-50A.
Got a motion, is there a second?
Second.
Got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye. Aye. Any opposed? Motion carries. Is that all of the motions?
Yes, sir.
All right. Thank you very much, Commissioner Thompson. Mr. Baywell, thank you.
Yes, sir.
That takes care of all the preliminary hearings. Madam Court Reporter, would you check and make sure that there were 6, excuse me, that there were 7 as opposed to 6. I'm sorry, but I just want to make sure.
Oh, yeah, right, he was just eating.
Sorry. It's not that I don't. It is. There were 7? Okay, thank you very much. I'll tell you. I'll explain that to you. All right, that takes care of item number 3 on the agenda. We're going to move now to item 4. We're going to hear all of these, I guess, together, and then we'll make one vote on the consent matters. Looks like Mr. Baywall, you got the first 6, is that right? Because we're taking D off?
Yes, sir.
Okay. We'll go ahead and call case number 24-0115-C in the matter of Stephanie Warma.
Ms. Warmoth was the successful candidate for Villa Rica City Council Ward 3 in the 2023 election cycle. She had one violation of OCGA 21-5-34M for failing to terminate her campaign account and file a termination statement within 10 days dissolving her campaign. She agreed to pay a $125 late fee, $125 civil penalty, for a total penalty of $250.
Okay, item B, case number 24-0112-C in the matter of Leslie McPherson.
Ms. McPherson was the successful candidate for Villa Rica City Council Ward 3 in the 2021 election cycle. In December of 2023, she resigned that position and then became the successful candidate for mayor in the 2023 election cycle. She agreed that she had 5 CCDR violations of OCGA 21-5-34C. She also agreed that she failed to file a termination statement within 10 days of dissolving her campaign. That's a violation of OCGA 21-5-34M. For those penalties, she agreed upon payment of $750 in late fees, $250 civil penalty, total penalty of $1,000.
I have a feeling that I should know the answer to this, but when y'all do these consent orders, is it just like one block amount of money, or do you see the breakdown for each separate violation? Does that make sense what I just asked?
Usually we block out the late fees because those by statute are $125. And then I probably look at a lot of things in terms of the civil penalty. I'll look at the size of the campaign. I'll look at how cooperative somebody is, whether they're getting their stuff in or not. I would say, so we don't necessarily, we'll have a starting point, I guess, with civil penalties, but I will deviate either way based on somebody's cooperation, based on what the errors are. If it looks like egregious errors, then I'm probably gonna take that base amount and, add some to it. If it's, somebody who mistakenly missed a filing, and because of that missed filing, they accrue 3, 4, 5 more violations unknowing to them, and it's because they made the one mistake, then I'm probably more favorable on the civil penalties.
Okay, so it sounded to me like with late fees, you'll break those out one at a time, and then the other one just comes in as a sort of block amount?
Yes, sir.
Okay. All right, next case, item C, 24-0036-C in the matter of Vivian Thomas.
Ms. Thomas was the successful candidate for Henry County Commissioner, District 4 in the 2018 and 2022 election cycles. She resigned that position in February of 2024. She then became the unsuccessful candidate for Henry County Commission Chair in the 2024 election cycle. She had 4 violations of OCGA 21-5-50A for failing to file calendar years 2019, 2020, 2021, and 2022 PFDSs. She had 10 violations of OCGA 21-5-34C Those were 10 CCDR violations. I will add too, this was a third-party complaint, and originally the complaint focused on the PFDS violations and deficiencies and other PFDSs that she filed. Ms. Thomas did have late fees prior to our complaint she was late, but actually got the filings done before the complaint came in. So in instances like that, we normally just go after the late fee. If we get a complaint after the candidate on their own has already made good on those filings. So several of those missed CCDRs were their older filings that she missed the deadline, but she did file those before we took action with the complaint. Violation 3, a violation of OCGA 21-5-34B1. I did audit Ms. Thomas's campaign, and I saw that on CCDRs that she previously filed, she was deficient in the amount of $8,262.93 in contributions that weren't reported, and $10,111.48 in expenditures that weren't reported. Ms. Thomas agreed to pay late fees in the amount of $1,750, civil penalties in the amount of $1,250, total penalty of $3,000.
All right, next is item E.
Excuse me.
Oh.
I'd like the opportunity to speak on this matter if that's possible.
This is
Thomas.
Vivian Thomas.
Yes, sir.
What's your name?
My name is Lauren Smith.
And do you have some relationship with regard to the complaint made against Ms. Thomas?
I am actually a District 3 representative for the Henry County Board of Ethics, and I just wanted to point out that in my time on,
Would you mind going over to the podium so that the court reporter can hear you? Right.
again, my name is Lauren Smith. Up until this meeting, my last meeting was March the 11th. However, I received a text message from the ethics administrator asking me if I could attend the next meeting as well because they haven't gotten someone sworn in. But I was sworn as District 3's rep in January of 2024. During that time, Ms. Thomas appeared before our board on 2 separate occasions. We had 2 separate hearings. Because of the nature of Senate Bill 22, we were really not able to get into the CCDRs and that. Because it was referred to you guys, we just basically said, we're not touching this part. But in the hearing, initially the hearing was scheduled for last February, and we received a letter from Ms. Thomas basically saying it was concerning and appalling that she believed the complaint amounted to election interference.
And I don't want to, I'm trying not to interrupt you.
Sure.
If possible. When you say the meeting, are you talking about one of our meetings, or are you talking
One of
about a
our-
local ethics meeting?
Henry County Ethics Board.
All right, and were the issues
The-
before
the
your
issues-
board, was it these issues at all?
Exact same complaints.
Okay,
So our
I'm trying to
board,
figure out the whole jurisdictional issue. Do you have any comment on this, Mr. Amati, about jurisdiction, I guess, of these matters, if they were filed with, the local ethics agency?
So, and I'm not familiar with the Henry County ethics rules specifically, but violations of these issues under Title 21 jurisdiction lies solely with this body.
Okay. So I guess,
Now, that's not to say that there aren't local ethics rules that maybe are put in place in Henry County, but as far as finding someone under the color of Title 21, Chapter 5, that jurisdiction lies solely with this commission.
okay. And again, Ms. Smith, I wasn't trying to interrupt you, and again, since you're here, I will go ahead and allow you to finish the statement that you had prepared. But again, I just want you to understand that the question that I had when I began hearing what you were saying was, with regard to the subject matter of this consent order, that would truly be something falling within our jurisdiction. But
correct.
some type of complaint, whatever the rules may be, there locally, we wouldn't have any control over that. So if you have comment upon the issues that we have here in our case, then, more than willing to listen to you on that.
Certainly. So Henry County Board of Ethics was created by Senate Bill 22. We are unique in the fact that we are the only we are the only Board of Ethics that was created by the legislature. So we're very new. Our board is very young, so we did not start having hearings until last year. In fact, Ms. Thomas's was one of the first ones that we heard. And I'll keep it very brief, but we are limited to public reprimand, a financial sanction up to $1,000, or referral to the solicitor for potential prosecution.
I'm sorry, for violation of what?
Yeah, right, this is the first I've heard of
The
this.
code of ethics.
Your code of ethics.
Correct.
Henry County,
I have a copy of it.
that the legislature did not do. Henry County created the code
No,
of
sir,
ethics.
the
The
legislature.
legislature.
Yes,
And does
sir.
that have anything to do with campaign finance in the code of ethics?
I honestly don't, I mean, I have a copy of it if you'd like to see it, but the complaints.
I was just curious. I just don't, I mean, generally, there's not overlapping jurisdictions. And, I'm not an attorney, but I've never seen that before. I've seen a lot of local ethics boards across the country, and they all have certain jurisdictions, but they never, in my experience, have never overlapped any state ethics.
Yes, sir.
Okay, thank you.
So I mainly just want to bring it to your attention that, again, I sat in 2 hearings, and the one I believe that is happening today that you guys are reaching a consent order on. We actually heard that hearing in October, and at the time, she was no longer a commissioner. However, she still introduced herself as a commissioner, and she made the statement that our board was being weaponized for political purposes. However, we found in one of these hearings that the violation was engaging in activities prohibited by law and inappropriate conduct by a member of the Board of Commissioners. And our course of action there was public reprimand. But I mainly want it to be known that as a citizen of Henry County and as someone that has heard these matters, $3,000 is a drop in the bucket. Ms. Thomas has 18 or more businesses, and that, I just don't think that
And
is.
I mean, I think that we've sort of gotten off track with regard to what we have here. And again,
Sure.
I appreciate the fact that the legislature may have created this body that you're talking about there locally for you. But it does sound to me like, again, there are different jurisdictional.
Certainly, but
yeah.
it's the exact same complaint.
Okay,
So,
okay.
just making
Well,
you
again,
guys aware.
Again, I thank you very much for coming down and providing us with that information. And if you have a copy of that, I wouldn't mind looking at it if you, I don't know if it's a copy you can provide.
Yeah,
Because
absolutely.
I would love to look at that, because again, I've never heard of that to this point. So we will definitely take a look at it. But Mr. Baywell, were you done on your presentation with regard to item C?
Yes, sir.
Okay. Mr. Knittel, you can give that copy to Mr. Knittel right down here on the end, and he'll get that. But thank you again. Next case I'm gonna call is item E 24-0100-C in the matter of Carmelita Grubbs.
Ms. Gomes was the successful.
Oh, Gums, sorry, sorry, go ahead.
Yes, sir. Ms. Gomes was the successful candidate for South Fulton City Council District 2 in the 2021 election cycle. She had 3 PFDS violations of OCGA 21-5-50A. She had 6 CCBR violations of OCGA 21-5-34C. And she had 1 violation of OCGA 21-5-34B1. There were $12,686.23 campaign expenditures that she omitted from previously filed CCDRs. She agreed upon payment of $1,125 in late fees, $1,375, and civil penalties for a total penalty of $2,500.
Okay, we'll move to item item F. 24-0110-C, in the matter of Gil McDougal.
Mr. McDougal was the successful candidate for Villarica mayor in the 2019 election cycle. He ran again in 2023, and he was the unsuccessful candidate during that election cycle. He had 6 CCDR violations of OCGA 21-5-34C. He agreed upon payment of $750 in late fees, $250 civil penalty, for a total penalty of $1,000.
All right, and item G, case number 25-0017-C, in the matter of Adrian Simmons.
Ms. Simmons was a successful candidate for Gwinnett County Board of Education, District 4 in the 2022 election cycle. She had 2 violations of OCGA 21-5-50A. She failed to file her calendar year 2022 and 2023 PFDSs. She agreed upon payment of $250 in late fees, $125 civil penalty, for a total penalty of $375.
And that's your last one?
Yes, sir.
Okay. Mr. McCarter, it looks like you got the last 2, is that right?
Yes, sir.
All right, item number H on the agenda, it's 24-0024-C, and 24-0081-C, in the matter of Elena Reeves. Did I
Yes.
pronounce that right?
Yes, sir. These were 2 third-party complaints. Ms. Reeves was a successful candidate for Clayton County Commissioner, District 1 in the 2024 election cycle. There were a total of 5 violations ultimately for this case, 2 PFDS, 3 CCDRs. I got in contact with Ms. Reeves, and she was very cooperative in my investigation. She agreed to get those reports filed, and we ultimately agreed to a $750 civil penalty to resolve this case. And I believe she's here. I want to give her a chance to speak if she wants.
1 second. Commissioner Thompson?
So generally, it appears on the last consent orders, when somebody missed a filing, there's also a late fee. Is it true that there is no late fee for this? And if so, why did we deviate from whatever our standard practice was?
I deviated. I usually deviate, and this might just be my practice.
Move that up a little bit.
Oh, sorry. Yeah. I just deviate and lock them all together as a civil penalty. After some internal guidance, I think we're going more for civil penalties when the cases are escalated to the attorneys. So that has been my practice, just resolving it all in one big fell swoop.
Okay, thank you.
Yep.
Okay, last item we've got here, item I, 24-0093-C, in the matter of Benny Crane.
Yes, Mr. Crane was a candidate for city council for the city of South Fulton. There were a total of 3 violations here, 3 CCDR violations. Same kind of instance, Mr. Crane was very cooperative, got in touch with me immediately after receiving the complaint. So we ultimately agreed to a $450 civil penalty to resolve this case.
All right, before we vote on any of these, I guess I have a question that I think that Commissioner Thompson has as well. We've got 2 of these consent orders. We've got the one for Vivian Thomas, and we've got the one for Benny Crane that have electronic signatures on them. What's staff doing with respect to these electronic signatures as opposed to actually having them signed? Mr. Amati?
Yeah, I mean, I don't think there's any legal issue accepting electronic signatures from individuals as long as they're communicating that it is in fact their signature, right? mean, if an electronic signature came through a consent order and we didn't have an indication from the individual that it was in fact from, they were emailing it to us, it was theirs, there could be a problem, but I believe when they indicate they're gonna send it e-signed, there's no issue with that.
Is there any kind of internal rule or anything?
I don't believe there is, no, sir.
Okay. All right. Does anyone want to, any of the commissioners, do you have any desire to pull any one particular consent order out in order to vote on it separately? Oh, I forgot. Ms. Reeves.
If you want to make a statement, you can.
Yeah, did you want to add anything with regard to your case? And I apologize, I got off track. If you want to make any kind of statement or say anything, Mr. Thompson's doing the best he can to keep me on track here. So again, you're more than welcome to make any type of comment that you may want to make with respect to your case. And again, it's actually cases.
Thank you for the opportunity to speak. I just wanted to make a brief statement in regards to the Clayton County Elections Office. There was an article that was written back in fall of 2021 in regards to unuploaded CCDRs and campaign disclosure and other documents on the Clayton County Elections website. And so I know myself and other candidates within a certain time frame didn't have that documentation uploaded directly to the Clayton County Elections website.
Was that taken into consideration, Mr. McCarter?
Yes, sir. I wasn't able to get that article. I believe you sent it to me, but the link wasn't working or something like that. And I don't doubt that it was written. I think it was written in a more independent newspaper, and they may have discontinued their service, but.
No, I mean, was there an issue locally with regard to the information getting uploaded? We know that may be changed at some point in time. But
Right.
for now, while the locals have it, was there some, issue locally with getting the information uploaded?
I have not received documentation of that issue. I can research further into that, but I don't have any confirmation on that myself.
Ms. Reeves, you still want us to go ahead with the agreed consent order?
Yes, I just wanted to make note for any additional complaints that come about within that time frame that there were some technical difficulties on their part.
Okay. Well, we thank you very much for coming this morning and giving us that information, and we'll move forward with the vote on your consent order.
Thank you.
Okay. All right, now I'll get back on track. Does anyone want us to pull any specific case out of all the consent orders to vote separately? All right, I'm not hearing that. I'll go ahead and make a motion that we approve the consent orders in item number 4 on the agenda, which would be A, B, D, E, F, G, H, and I. Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, that motion carries. Item 5 on the agenda is administrative dismissals. Mr. Amati, is there any comment with regard to the administrative dismissals?
No, sir.
Do any of the commissioners have any questions or comments with respect to the administrative dismissals? I don't hear any, so we'll go on to item number 6, is the report of the executive director. Mr. Amati?
Thank you, Mr. Chairman. As the board, as the commissioners all know, we are in the midst of legislative session, so I have a few items to update you on. I'll start with SB 199, which is an agency priority. It's legislation that I proposed. We have Chairman Sam Watson in the Senate has carried that for us, and Representative Chaz Cannon will be carrying that in the House. This is a bill that does a few regulatory things that I think are overdue, and it's kismet timing that we're hearing about local technical issues, because this bill proposes effective January 1 of 2027 to bring all filings back to the state. And I think the Vice Chairman and I and all the board members and I have talked about this over the years. This is something that is desperately needed. I think there's inconsistency with local county and city filing clerks. Different legal advice is given, and it's just appropriate for that jurisdiction to fully vest with us. I'll note also that this proposal actually has, and this bill in general has the full support of ACCG, GMA, and Gavrio. So we've got buy-in from all of our local officials as well.
Who's Gabriel?
It's the Georgia Association Voter Registration and Elections. I may be butchering the acronym a little bit. We're also proposing changing the filing schedules. As the board knows, currently in an election year, candidates have 6 reports due on their campaign disclosure side. In non-election years, they have 2 for elected officials. But those 2 differ depending on what office you hold. There are different report dates due if you're a retired official versus just a defeated official. Different office types have different dates. We're proposing moving it to quarterly every year, the same 4 days every year, irrespective of what office you hold or whether you are still in office or not. I think the feedback we've gotten has been positive from the candidates, that there's just some consistency and logic to it. We've set those in a manner that ensures in election years, reports still come out shortly before the primary and general election, so there's no lack of transparency or disclosure with the public. That was very important to us. We're moving the financial disclosure report dates. Currently, in non-election years, they're due by July 1st. In election years, they're due either 7 or 15 days within qualifying, depending on the office type held. Again, very inconsistent between different office types, different officials. We're proposing that be moved to one consistent date each year. In an effort to keep that, again, like the campaign reports, shortly before primary election, so that the voters have that information. We proposed that would be April 1st of each year. I couldn't think of a more fitting day than April Fool's Day for the public officials to file their financial disclosure reports. With one exception, and I want to thank Gavrio and their officials who pointed this out. In municipal elections, they actually don't qualify until August. So we actually had to carve a special date for those officials to ensure everyone is in fact filing the financial disclosure. So for municipal office holders in election year, or for every year, it'll be September 1st.
I have a question.
Yep.
So now that you said that, what happens if there's a special election?
So we're not changing that statute.
Okay.
Special elections remain within, I think it's 7, whichever date it is, it's still within that number of days. And I'll point, that's a really good question, because with campaign disclosure reports as well, with special elections, it's still within those prescribed dates. We're not touching that. We're doing this. We're doing something similar with lobbyists. Right now, they have 2 reports during some months, 1 report during others. The dates are different between the 2 report months and the 1 report month. We're moving that to to the 5th day of each month. We're also, and I think this is a really good thing for the public. Right now, if you're a lobbyist, there are 5 different types of lobbying you may do between state, general assembly, state vendors, state agencies, business transactions, local lobbying. And if you have those 5 reports, those 5 registrations, you do those types of lobbying, you file 5 different reports in the same month. So if you, John Doe, and the public want to find out who lobbyist A is lobbying, you have to go through 5 different reports to get that information. We're collapsing it into one. It's easier for the lobbyist to file 1 registration, 1 report. It's easier for the public to find that information, access it. I think this is a good change. We are redacting home addresses for public officials and candidates from office and public view. Candidly, this is not necessarily something I would have supported 10 years ago, but we've seen a significant increase in swatting. I actually proposed this at the biennial in December, that Vice Chairman Thompson served with me on that panel, and within a couple days of that proposal, there was actually a swatting incident where someone was killed in response to police, rushing onto the scene. So those home addresses will still be disclosed with the commission. We will still have that. It will just be redacted for public view. This legislation, there are a few other components to it. We're extending the sort of icing period where we don't accept complaints from 30 days before an election, which is the current state of the law, to 60 days, trying to cut down on the weaponization of sort of frivolous complaints at the last minute. But this is a piece of legislation that has passed the Senate. It was reported, I testified, it was reported favorably out of Government Affairs in the House last week. It's now in House rules, and I expect it to get a vote on the House floor, either this week or hopefully the beginning of next week at the latest. But that's the sort of substance of SB 199. Have to take any questions about it, or I can move on to HB 414. 199. It'll be on the House floor probably later this week. It's passed the Senate. HB 414 is another piece of legislation that we've been working on with the General Assembly. This deals with essentially long-arm jurisdiction and granting that power to the state. Right now, there is an incentive for bad actors, that if you want to spend illegal dark money attacking someone, you can go out of state, hire a vendor, pay them, and have them flood with mailers into the state. This would give us the ability, through a court order, to obtain that evidence from the out-of-state vendor if we know who they are. And so this has passed the House. Wasn't unanimous, but it was, 130, 140 to 10 or something. It's passed the House. It is passed out of Senate Ethics and is now in the Senate Rules, where, again, like 199, we expected to get a vote in the Senate floor within the next week or so.
In order to do that out of state,
Yes.
do you have to get a commission over in the other state to enforce?
Currently, it's either a commission in the other state helping us out, which is not always a guarantee, or the Attorney General's office and a friendly Attorney General. What this bill would do is say, if we have an investigation and we need this authority, we can ask for it. And if they refuse to turn it over, we would go to a superior court in Fulton County and show that, and a court order would help further this investigation. And at that point, the court would issue the order.
And I'm sorry, I was talking about an out-of-state commission, not another ethics commission in
Right.
another state. You know what I'm talking about? Do you have to go through that route? Do you have to get like a superior court involved in another state in order to enforce the order or subpoena from the state?
So the thought is, worst case scenario, yes, but the thought is another court would be more inclined to honor a Fulton County Superior Court order than an out-of-state agency subpoena. SB 177 is a piece of legislation we're following. It's actually something that passed the General Assembly last year, was vetoed by the governor after business communities raised some concerns about unintended consequences. They've refined that bill to address those. And I believe this has passed out of the Senate. It is in House rules, where I expect to get a vote in House floor again in the next week or so. What this bill does is essentially a version of the Foreign Agent Registration Act the federal government has, would just require people who lobby on behalf of foreign entities, non-American entities, to register that information with the commission so that it's publicly available. Those are the three primary bills we've been working on and tracking, but I think as several members of this committee know, this is the time of the year where ideas that didn't pass find their way magically onto other bills. So while I'm optimistic that we're going to move agency priority legislation well in advance of sine die, I will be tracking anything with Title 21 attached to it very closely, because I expect some other things to pop up. In fact, I think an AI bill from last year has actually reappeared in a Senate bill over in the House that we didn't anticipate coming this year. So there are other things that may come up, but I'm staying on top of that. HB 68 budget update. My update for you is that we are in the midst of budget negotiations. I think we're working with the House and Senate to get some things solidified, and hope to have good news in June and I think the Senate's probably going to release either tomorrow or Wednesday their proposed version of the bill, the budget bill, which I think will be very different from the House's. So I would expect that to go to conference committee as usual. The last thing I'll update the board on, following our meeting a couple months ago where we resolved the New Georgia Project case, which resulted in them admitting to illegally supporting the Abrams campaign for governor in 2018, as well as a few others in the general election. A few things I think it's now appropriate for me to update the board on now that that case has been closed with this commission. The state senate has dropped a Senate resolution expanding their special investigation subcommittee to include the Abrams nonprofit as well as New Georgia Project. Obviously, that's within the purview of the state senate, but assuming that does pass, I do expect we will be called as witnesses before that subcommittee at some point in time this year. Additionally, we've received inquiry and requests from Congress and the United States House of Representatives, the House Committee on Administration, which hosts the Subcommittee on Elections. They've indicated they have an inquiry and investigation into dark money and illegal influencing of American elections. They've requested the full case file, and if and when they hold their hearings, I do expect we will be subpoenaed to testify in that inquiry as well. Finally, I will update y'all that we've had a lot of questions coming in regarding the nonprofit, their activities, and the legality of that. Previously, I did refer the New Georgia Project case to the Department of Justice, specifically their IRS division, for an inquiry into whether federal tax fraud laws were violated. And after sort of reaching out and making that overture, I did meet with officials from the Department of Justice, provided them sort of a overview of the case, provided them the evidence we had at the time. And so we have sort of made that recommendation, that referral, as statutorily required, I believe. But with that, Mr. Chairman, I believe that concludes my report.
Item number 7 on the agenda is the report of the Attorney General's office. How are you?
I'm good, how are you? Pleased to say that, since the last time I saw y'all, we've had, in general, both with the commission and across our section, a cooling down of things on the litigation front. Our one piece of major litigation involving this commission is a case that's pending in federal court, Northern District of Georgia, and this is, I believe, lawsuit number 4 or possibly 5, related to our leadership committee statute, which allows candidates for governor and lieutenant governor in Georgia to form leadership committees and raise funds without being subject to campaign limits. The latest version of this litigation is filed by the Libertarian Green parties in anticipation that they will run candidates in 2026, and they're seeking an order that would either prevent other candidates from raising funds in excess of limits, or what they would prefer would be to be allowed to have their candidates also be able to establish a leadership committee. We had filed a motion to dismiss their complaint. They have now amended their complaint to add some allegations in response to our motion to dismiss, so we'll be filing a renewed motion to dismiss that on Wednesday of this week. And we will keep y'all updated as that goes through the pipeline. Typically, this Judge Cohen, who has been the judge in each of these cases, has done one of two things, which is either dismiss an action on technical grounds, or if not, has tended to award some kind of relief to try to level the playing field with regard to this particular statute. It's too early to predict which way this particular one will go. With the cooling down of election and campaign finance related litigation, I am pleased to say that due to that, and also due to some restructuring in our office, I have got 2 lawyers right now working very diligently on administrative cases. We have about, I think, 7 of them right now, ready to send over to OSA. We're just talking with Mr. Knuddle about making sure that we get convenient hearing dates, and are very much hoping that during this time that we're not drinking from a litigation fire hose, to really push all of our administrative enforcement cases forward as much as possible in anticipation of 2026 bringing some excitement down the road. So this is our time to really get those moving for y'all, and hopefully I'll be back at the next meeting to report on the outcome of some of those.
So we've got 7 in the pipeline ready to go over. Do we have any over at OSA now?
No, we're holding those just to get, to discuss hearing dates. But right now, we don't have any that are officially set for hearing dates. But I do have, more to come that are being drafted up, with these, I think you met Ms. Yu, who was here the last time in my stead, and Alex Noonan, who's our most recent hire, is, working on a lot of this.
Okay. Thank you very much, Ms. Young. Any questions or comments from the commission for Ms. Young? All right. We'll move to item 8 on the agenda, public comment. It looks like we've got one person signed up for public comment. Tommy Travis from the South DeKalb Coalition.
Yes.
Good morning, Mr. Travis. How are you?
Great, how are you?
Doing fine, thank you. Looks like you know where to go.
Yes, thank you. Good morning, Commissioners. My name is Tommy T. Travis. I am a longtime South DeKalb resident and a community advocate and a member of the South DeKalb Coalition. I'm here regarding a case that you guys have not heard yet, which is 24-0098-C. The filing for that case was originated because the complainant was very late originally in their campaign filing of their financial disclosure information. Sometime after that, the complainant was notified, and the complainant.
Mr. Travis, I don't want to interrupt you on this. I really don't. But if this is a pending case that's in the pipeline, I don't want the commission today to receive any type of comment or evidence, related to that case, because it's something that we're gonna either hear in the future, one of two ways. It'll either be in a consent order that's worked out before then, and if you wanna speak on the case at that point, I perfectly understand. Or it could be, more importantly, for why I'm saying what I am today, it could be in a preliminary hearing status, which would be where this commission would have to hear evidence to determine at that time whether there were reasonable grounds to, whether there are reasonable grounds to believe that the Campaign Finance Act has been violated, with respect to the allegations that are made. This is no attempt, and I want you to please understand that, this is no attempt for me or for this commission in any way to shut you down today on anything that you're saying. I just hope you understand what I'm saying with regard to the procedural posture that we may be in with a pending case as of this time. Does that make sense?
It makes perfect sense. And, well, can I give my closest statement that does not give you any details?
Let me say this
Mr.
too.
Thompson?
I think you can also get with Mr. Canetto if you have any information on the case that may help the case. And I don't even know where you were going on it, whether you were gonna, help it or hurt it or whatever. But you can get with Mr. Canetto and share all your information with him, and he'll make sure it's part of the investigation, or at least vet it, hopefully, if you're not tired. What? Yeah, you can get with him and he'll definitely be able to hear you out.
At that point, the communication has been very great amongst them. I'm just concerned that if the hearing does take place at the next hearing date, which is, I believe, down in Savannah, that the local people of South DeKalb won't have an opportunity to come and be witness to
Well,
what.
I'll tell you, I think that the next meeting is in Athens. For the June meeting is in Athens, but either way, again,
That's a lot.
we don't necessarily want to make you have to travel there. Can we make, I'm just asking staff on this, is there some way that we can make arrangements for them to come in by Zoom, or is that not a thing anymore?
We can do that.
We can do that. Since you've taken the time, again, I don't know if we're doing that as a matter of rule or what at this point in time, but I'll say that because you took the time to come here today to make a presentation, on this particular case, I'll make it where we set it up and you can at least attend by Zoom or make a statement in that form. Is that okay?
Yes, that's very acceptable. Thank you so much. I appreciate you guys.
Thank you. Good. Is there anyone else set up for public comment? Okay. Looks like there's none. We're gonna move to item number 9 on the agenda.
Move to adjourn.
We're out of here well before the time that they told us we had to. So I've got a motion. Is there a second? Got a motion motion and a second, any discussion, hearing none, call the question, all in favor say aye. Aye. Any opposed?